We have breaking news we want to share with you right now on this case. The court has just ruled that Marcus Wilson will not be given immunity. Want to be very clear with this. This is not a finding of guilt by any stretch. This is only as to whether or not he should be given immunity under the statute and have these charges go away before any trial happens. So what's happening now, because the court denied him immunity, his case will in fact proceed to trial. They've even set a date, April 18th. Will be the date that this case will go to trial. So he can still argue self-defense at trial. But in terms of having these charges go away ahead of trial, the court has said no after listening to 3 different days filled with testimony. And we've been going over much of that today, and we'll continue sharing it with you here on Court TV. And of course, when this case goes to trial, we will be there as well. But for now, no immunity for Marcus Wilson. The case kicks off April 18th. Let me bring in my guest now for some reaction to the judge's decision. Still with me, criminal defense attorney and former federal prosecutor Michael Sterling and retired DEA special agent Ted Golden. Michael, want to begin with you, if I may, please, your reaction.
Yeah, Julie, I can't say that I'm surprised. And I think this is important for the Court TV audience to understand that we're talking about evidentiary standards, as you mentioned in your assessment. So the court didn't find that the defendant proved by a preponderance of the evidence that he was entitled to immunity from prosecution because of his defense of others or his defense of himself. When this case goes to trial in April, he will then be allowed to use much of the evidence that was presented in this pretrial phase at trial. And at the trial phase, the burden is not on him. All he has to do is raise the affirmative defense of self-defense and present some evidence in support. Then the burden shifts to the prosecutor to disprove self-defense beyond a reasonable doubt. So I know folks hear these terms thrown around in the Court TV audience, these evidentiary standards, but they're really, really important to how we adjudicate these cases and how these cases are decided, whether it's probable cause, preponderance of the evidence, clear and convincing evidence, beyond a reasonable doubt. These standards mean something because it determines what level of proof is required for you to meet, the various burdens in different cases. And in this particular case, I'm not surprised that the judge didn't find that he didn't meet his burden by a preponderance of the evidence.
Michael, appreciate you explaining all of that, because I think the one thing that's really hard sometimes to be mindful of with criminal cases is that any defendant is cloaked in the presumption of innocence, unless and until a jury or a judge sitting as the fact finder finds them guilty beyond a reasonable doubt. And here that hasn't happened yet. And I know you gentlemen, you know that very well from your work in the criminal justice system. And even though this looks like a mini trial that we've been watching and following the last couple days, not a trial, not a finding of guilt. This is just that, hey, this case needs to go to trial. Ted Golden, let me go to you for your reaction next, if I may, please. Being in law enforcement, it's folks like you who do the investigatory work, prepare the case, recommend charges to prosecutors to move forward with. You've seen a lot in your years. What do you think? Are you at all surprised with the court's decision today?
No, I'm not surprised. I thought that the fact that they didn't have a weapon was a negative in this situation for the defendant. The fact that they did use the car, though, also is an issue. And a young man who pled the fifth was also an issue. I thought that the judge would be more amenable to looking at it as defensible by that fact. But the standard questions that were asked, the questions of the other witness that the defense did, prosecution did, was a little bit badgering, and it is something that attorneys use to try to get people to stumble on what they say. I was kind of confused by the other young lady's statements. They were asking her questions about what she told her friend. That to me sounds like hearsay. It's not evidence. But again, this is a hearing of the purpose of determining whether or not he claims stand your ground. So I could.
Mm-hmm. Agent Golden, if I was your evidence professor in law school, I'd give you an A+, because you're absolutely right. That is hearsay, and there was no objection that was lodged. And Michael Sterling knows if there's no objection, it's coming on in. It's part of the record. Amen. And these attorneys on both sides can use this record, as you gentlemen know, as we proceed to the trial phase. We're going to talk about so much more with this case. I have so many more questions for our guests, but just a reminder, April 18th, that is the date. So this is going to come up pretty soon when this case will head to trial. Again, it's happening in South Georgia. No immunity for Marcus Wilson.